Broker responsibilities and assistance. You got 4 test questions here. I think of the 4, 2 of them are going to be what a licensed and unlicensed assistant can and can't do, and who is ultimately responsible for them. I think that's 2 out of the 4. I'm just going to shoot that 2 out of the gate right now. Now, in this section, it emphasizes that you've got to disclose if you're going to represent yourself or immediate family. We already knew that. We also know that we've got to have a designated broker in each office, unless it's an affiliate office. Then we can have one broker manage both of those. We know anytime a license needs returned, the standard number for that is 72 hours. We know that if a broker loses their license, so do the agents underneath them, and we cannot be selling real estate. We cannot be selling real estate. We know that idea of when we owe a progress report. It's upon request. After an offer to buy has been made by a buyer and accepted by a seller, either party may demand at reasonable intervals, and the broker shall furnish a detailed statement showing the status of the transaction. So not every 5 days, not every 10 days, not every 30, it's upon request. Again, we know if there's any commission dollar or compensation controversies between brokers, we don't go to the real estate commission for that. They're only there to protect the public. Then another 1 or 2 questions of the 4 I think are going to be around advertising. Know that when a broker closes their office for any reason, they've got to remove their advertising within 10 calendar days. And then we also know those 4 basic items that we need to include in advertising, which is the license full name, licensee's full name, number 1, name of brokerage, number 2, city and state where the brokerage is located is number 3, and number 4, where that agent holds a license, such as licensed in Iowa or any other states where they hold a license. We do not need a license number on our advertising. Your broker's name, at minimum, must always be on your ads. When in doubt, that's your top priority, is your name with your broker's name. So we've got a few options that they could test you on. Then when it comes to a broker or an agent that works underneath them, hiring unlicensed staff, here's what we've got to know. If a broker hires unlicensed staff as an employee, for example, that maybe manages the trust account as an accountant, they can do that, but they're ultimately responsible for that employee, for that staff member. So if the trust account books don't balance, they can't say, well, I hired Amy to do it. She's my accountant. No, they're ultimately responsible for any advertising, the trust account, the contracts for their brokerage. So even if they leverage the work to someone else, such as filling out a settlement statement, they are still responsible for it. Now, the next layer is, what if an agent working for a broker hires an unlicensed assistant to help them with their business? Who is responsible for that person? And the answer is the broker is still responsible, but the agent that hired them has the utmost amount of responsibility. And some of you will hire an assistant, even though you're not the broker. You're a salesperson. Some of you will choose to hire an assistant. I've had a version of an assistant since 2011. I've had a transaction coordinator. I don't know what I would do at this point without her. Then we had a list of permitted and prohibited activities of what this unlicensed assistant can and can't do. They can only do things under your supervision, such as contacting a vendor or any advertisement. They cannot host a public open house alone. They can make copies of keys and they can open the door for a vendor, but they can never select the vendor or review any results that the vendor provided with a client. Are we good on that one? Then we've got 2 test questions on property management agreements. And I would review the minimum required items on a property management agreement. We've got to identify the property. It's got to have a start date and an end date. It's got to describe what scope of work you're providing for that client. It's got to discuss your commissions and when it's going to get paid. And then it needs signatures, right? So I would review what goes into that just in case. Now, of those 2 questions, here's another option. What happens when a management agreement ends or is terminated between a broker and a landowner? Well, it's the broker's duty to notify all the tenants where their security deposits are now going to be located and who their new contact information is. That's going to either be the landowner or a new property manager. They've got to disclose that. The last section of this that would be a good test question as well is how do we work with financials on behalf of our property owners when we're doing property management? Well, if you are going to be having access to a client's bank account, that needs to be in writing. The next layer is we can't write any checks or post anything to that account that would put it in the minus or in the red. So don't write checks that won't clear. Duh. The third level of that is if you're going to be managing multiple bank accounts for the same owner and you're going to transfer money between them, no Dumb and Dumber IOUs. We're not going to cook the books with a ledger. We're actually going to provide billings and receipts. Billings and receipts. And then the last thing, you're going to have 1 token test question about the Iowa Civil Rights Act of 1965. And what you already know that we've learned about fair housing previously in the national content is going to help you here. What I want you to know is that race was the original protected class. Then we've amended it to include the others, but race is the original protected class. Some other things I'll highlight here in your notes are we cannot say a property is no longer available when it really is actually vacant. And we cannot tell a tenant that they cannot have certain visitors. They've got to be allowed to have visitors. That's one that this points out. And we cannot do anything that would be retaliating. That's also part of the Iowa code, that if I've got a lease with a landlord and I file a complaint, he can't retaliate against me by raising my rent or refusing to do repairs and breach the contract or harassment. That's another one that'll pull out. I would review this content, but again, my key thing is you got to know the original protected class was race. That's very, very helpful.